They start with a presumption of shared parenting, and then based on the facts of the case, they move either way, either direction. I applaud Madison County. I think there's Representative Ball's district, so they're doing an outstanding job. 7 judges up there is using the social science data, and my bill does the same thing. I'd like to take the opportunity to applaud our neighboring states, the state of Kentucky. In 2018, they actually, in their child custody laws policy, actually is a little more stricter than my bill. I'd like to also applaud Arkansas. The state of Arkansas last year passed similar legislation that creates a rebuttable presumption. Some people feel that the rebuttable presumption take away judges' discretion. Well, this very body right here passed the grandparents' law 3 to 4 years ago, and guess what in the grandparents' bill? It's a rebuttable presumption. So we just trying to make our code consistent, given the court's guidelines. And so before I leave here, I'd like to share what our best interest of the standards has resulted in. Alabama was ranked the 3rd worst state in our nation in overall child well-being. That means that 47 other states are doing better than Alabama when it comes to our kids. We had one representative came up here talking about fathers being involved. I said the same thing a long time ago. We need to get dads involved in the child's life. But after research, I found out the #1 cause of fatherlessness in our state and our country is our court system. It's not the 5% that abuse their kids or walk away from their kids. The 95% reason of fatherlessness in Alabama is our court systems. And then later on, we put our kids in our correction facilities. According to Alabama DHR, children who grow up without either parent, they're 5 times more likely to live in poverty. They're 3 times more likely to fail in school. They're 2 to 3 times more likely to develop emotional and behavior problems. We're not seeing it in our communities now, are we? They're 3 times more likely to commit suicide. Several years ago, I was at the Hoover Library doing an information meeting on this topic. And there was a grandmother sitting in arm's reach. She said, "Kenneth, what can I do to see my grandkids?" I said, "Ma'am, there's a grandparents' rights law." I said, "What's going on?" But after talking further, she said, "Well, my daughter just committed suicide." She said, "My daughter just committed suicide." So my point is, this is not just about a father's thing. This is either mom or dad. That child need a balance. But in this case, the mother could not withstand the stigma of being an every other weekend mother, and she committed suicide. So what this bill can do, Representative Roberts, what this bill can do, it can make a difference in our next generation. In Alabama, approximately 40,000 kids each year go through our courts. 40,000 kids. When I shared it with our AOC, they said, "Kenneth, that's a high number. That's a big number." So I went and sat with them and shared, here's what we're doing now in the 67 counties in Alabama. We killing our kids. In fact, this is unbiblical. Our current family law practice besides Madison County is unbiblical. So what I would like to do, I would like to at least start with one step there, Representative Roberts. Let's do one step right now, and I need your help. I would like to just update our public policy to acknowledge that it is the intent of the legislature that this act be implemented in a manner that recognizes the importance of family and the fundamental rights of parents and children. The goal of joint custody is that the children have approximate equal time with both parents, although that goal may not be fully reliable in all cases. This is not changing the definitions of our code. It's just making this public policy saying that we care about our kids. That's all I'm asking. So with that, Mr. Speaker, at the appropriate time, I have an amendment to offer.
All right, I believe this is the time. Clerk, proceed the amendment.
Amendment to House Bill number 314 by Representative Pascal.
And you won't give any more explanation to your amendment? Keep and watch your time. Be mindful of your time.
Okay. This amendment is just adding to our public policy, our existing public policy that states is the policy of the state that kids have frequent and continued contact with both their kids. We never in our history have acknowledged this. The amendment is simply stating it is the intent of our legislative body to recognize the fundamental rights that they're important for our kids, our parents and kids. And then also is stating the goal. Our goal is of joint custody is kids have approximate equal time, not 50-50, but the research said kids have better outcomes when they spend 35% to 50% time with both parents. And also, we acknowledge we can't do it every single time, but at least let's put a goal out there and move forward. Okay. With that, Mr. Speaker.
All right, we have the amendment on the floor from the sponsor. You want to comment?
I would like to comment. I won't take long, but you've made a lot of points and a lot of conversation here that I'll respond really briefly. Take me 2 to 3 minutes. You keep talking about social science, data, science, and you keep saying, I have the science, right? And you keep saying that 35%. So let's talk about the science. Dr. Mary Elizabeth Kirtner Smith wrote a letter, and you reference it, where she does say that 35 to 65% custody or visitation with the child is in that child's best interest. But what she also says their report provided was that social science experts have never agreed that a rebuttable presumption for legal joint physical custody is best for children. So the science says a rebuttable presumption is not in the best interest of children. So I just feel like you came down to say I have to clarify what I said. So I'm just trying to clarify what you said so the body knows that rebuttable presumption, no social scientist actually says it's in their best interest. Also, what you said that I think we need to really discuss is that you said nowhere in the history of Alabama have we set a policy that joint custody or custody of our children is in the best interest of children. As I mentioned earlier, the code already says it's the policy of the state to assure that minor children have frequent and continuing contact. We already say that. We've already said it. And yes, it is a fundamental right to have access to your children. But what I'm worried about with this First Amendment that you have, it conflicts with what is in this bill. And by changing and just shifting the definition of legal custody just a little bit, it can create havoc in the courtroom because it won't be clear on what legal custody is. And I also think we need to address the fact that, or we'll address that later when you bring the other amendment on rebuttable presumption. We go further in detail on what that is. But I would ask the body to lay this amendment on the floor. It does not improve the bill, and I just ask for a no vote on.
Well, here, let me.
And actually, I do want to say one more thing. Do you know the name Brian Bunning?
Do I know the name of who?
Brian Bunning from Madison County. You continue to say Madison County is the ultimate in child custody, correct?
Well, no, I didn't say that. I was telling you what they did July the 31st.
Well, now I have my right to reply. And I'm going to say, you said that Madison County is the example we should all use, and your next amendment is going to say we should move to Madison County. Well, the name Brian Bunning last year was in a court in a custody case, all right? So during the pendant light proceeding, he had to have visitation with his child because of Madison County's laws. He killed his 10-year-old child and killed himself out of spite to his wife. So that is the policy that we would inflict on this entire state if we forced a rebuttable presumption on our judges. We would force murders and suicides as opposed to a judge deciding what's in the best interest of the child. So when we talk Madison County, I want everyone to think of the name Brian Bunning. Well, and that would be Alabama.
I spoke to the family, just so you know. They called me. They didn't call you.
All right. Hold on. Let's stay on track here now. You've had your 10 minutes. You've made your amendment. Your amendment's on the floor. I always give respect to the sponsor to respond to an amendment that comes from the floor. All right, and Representative Robbins, you made some comments, which is you're right to do. Now, your question is, do you want to allow the members to vote on this amendment, or do you want to make a motion to table this amendment?
I would like to make a motion to table it.
Okay, all right. Debate has ended now. Let's go ahead and let's vote on the tabling motion. If you are in favor of the tabling motion, your vote will be aye. If you're opposed to the tabling motion, your vote will be no. We're voting on the table motion now, okay? All right, and if the clerk will unlock the machine and the members will vote. We're voting on the table motion. All the members voted? All the members voted. All right, clerk will lock the machine, record the vote. And Mr. Clerk, let's check our vote numbers here. Because my screen always sometimes comes up with the wrong number on the percentage. It says it. Okay. All right. And the table of motion does prevail according to the numbers on the clerk's screen. All right. So at this point, we are back on the bill, and the chair recognizes. We got a few more lights on. The chair recognizes the lady from Mobile, Representative Wilcox. We're speaking on final passage.
Thank you, Mr. Speaker. Thank
Yes,
you,
ma'am.
Representative Robbins. You know, I'm struggling with this one just like Representative Shedd. I don't think, members, that there's any bill that is more important than what we're voting on today. And then I've been looking at the bill, reading it, and then I heard a reference from Representative Hill about, what was it, tender years? What was
The 10 years doctrine.
And when I went to Google it, it said prior to the 19th century, we deferred to the man or the father because he had a better opportunity to financially provide for them. It was only after the 19th century that the presumption went to the moms. And I've looked at your bill. I don't find, I think now it looks like this bill is giving the presumption to the kids. And Representative Pascal, I love you. I have seen you down here fighting for fathers' rights as long as I've been in office, so since 2014. So I respect and I've wanted to be with you on this, but I'm really just trying to put myself in the place of the children. And I don't think we can legislate fathers. We're talking about kids showing up in court, and the crying shame is if both parents were there and thinking of the kids probably wouldn't be in court. So I totally agree with you on that we need the parents to step up. So I guess I'm coming up in support of your bill, but darn, I sure wish we could, make Representative Pascal happy as well.
I agree. I wish we could, but I want you to know that Representative Pascal's fingerprints are all over the bill. I mean, don't believe that just because he doesn't agree with everything about it, his movement, his pushing has helped make this bill happen. So I view it that Representative Pascal has made this bill happen. So I give him a lot of credit here. So I don't view it as voting against him. It's just whenever two people or groups, there's always going to be a few sticking points for each person. But Representative Pascal has done a tremendous job, and I applaud him, and I think this bill is a result of a lot of his work.
Well, thank y'all for both working on this issue. Like I said, the way to get our kids back on a forward path and a straight path and a good path that they're productive citizens is for all the parents to work together. And I agree with our chairman of the Rules Committee that I've seen people just lose their ever-loving mind when they're going through a divorce. I have, I've lost friendships over the way people behave in a divorce, and I refuse to go down there when anybody asks me to, because that's just not other people's place. They can't handle it in their household. By the time they get to the court, everybody has lost. So Thank y'all for indulging me. I don't know that I offered anything to help with this bill, but I wanted to give my thoughts on it and my respect to both of y'all for working so hard on it.
I mean, your presence always adds things, so thank you for coming down.
All right, and the chair thanks the lady. Chair recognizes the gentleman from Montgomery, Representative Hassel.
Thank you, Speaker, for recognizing me. Gentleman Yield.
Yes, I will.
Well, I'm going to give you my experience. First of all, I commend both of you guys for even bringing this up, because I had to go through the court system myself with my son. And I didn't see my son for 7 years because the judge said, you have visitation on her terms. And she went to court and made it seem like I was this pretty much gangster guy. and I didn't see my son for years and tried my best. And one judge went and overturned the other judge. But just taking a look at this, I acknowledge it. I appreciate both of you guys trying to do something about it. But it is hard, and I prayed, and I prayed to God for divine intervention that my son, he's 18 now, but he loved me like I always been there. And I thank God, I think that was a divine intervention because I didn't see him. I thought he was gonna hate me for it. You know, he was gonna blame me. She talked negative about me in the court to him. And he tell me all this stuff now because he's so much older. But something has to be done. And I'm just, like the lady said before, it's a situation that's very tough. But I know it's hard to legislate what a father should do. I was one of those dads who wanted to spend money on his child. I was one of those dads who wanted to spend time with his child. But I was not allowed to through a judge's order. So I hope that we come to some kind of agreement here where we can just do this and get it done so some of these dads or both, something can happen. Because that's an incident that happened in Madison County, but I'm on the opposite side of that. You know, I was not allowed, because of a judge's order. So, all right, that's all I had to say.
Well, I'm sorry about your situation,
Yeah,
and I hate that, but thank you for coming down.
no problem.
And the chair thanks the gentleman. The chair recognizes the lady from Madison, Representative Hall.
Thank you, Mr. Speaker. Will the gentleman yield?
I will.
You mentioned the case in Madison County, and it's interesting. I was just sitting there thinking I'd had an opportunity just this past weekend to speak to the mother of that child that the father ended up killing in himself. And so when I look, is there any place in this bill that would address the concerns that the mother had or that the family had relative to the father and his relationship at that particular time?
Could you repeat that? What do you mean exactly?
You indicated an issue where the judges had ruled in favor of Madison County. I'm talking about Madison,
Okay.
Madison
okay.
County
I'll answer
case.
your question. So the way that Madison does it is that it's called pendent light. So that's Latin for the pendency of litigation. So there will be an initial order entered
Right.
prior to the judge hearing the case and he or she making their decisions.
Right.
So during that process, there would be equal visitation regardless of what the visitation had been prior. So if it takes a little bit of time to get into court, they're going to have equal time. Well, this bill is based solely on allowing visitation, allowing a judge to determine that visitation and not forcing things during the pendent light proceeding, during that time period on a child that there might not have normally been accustomed to. Does that make sense? So you don't force it on them. It's just not in the bill.
All right, so use that case. I'm just generally for me in terms of the process.
Okay, so in the process, mom and dad, they separate. They
Right.
move to different houses, or they go and they file a divorce. They file for divorce.
Right.
They can't agree on custody and visitation of the
All right.
child. Well, with their divorce proceeding, because in Alabama we have it all together. We file for divorce. We let the judge determine those custody arrangements because the custody agreement could not be entered between the parties. During the time before that judge makes the decision, before the trial is over and the order is entered, that is the time period in what happened in Madison County, to my understanding, is that it was before the judge could enter the order, so they would force and say, well, equal time is best for the child, so we're going to enter a pendant light order, which is we haven't had time for trial, but during that interim, this is the way it's going to be. And they don't take, there's no consideration of factors on mom has never been in the picture or dad is abusive. It's fact, they don't take in those factors during the pendant light process. Where this bill my bill would not have that sticking point. And so the bill we keep talking about as a comparison pushes the idea of equal time is best. And you have to overcome that by evidence.
Okay, stop right there. What in this bill might have prevented, maybe that's the question I need to ask, what is in this bill that might have prevented what happened with that family? Is there anything in this bill that might have prevented what happened with that family? And if not, what is it that can be done to address the issue that exists presently?
Well, I think there's several factors. I can't say, and I've talked to Representative Pascal about this, and even Margie came down and talked about it.
Right, but I'm taking this case because let me tell you, because the family is really looking at what could they have done, what could we have done to possibly have prevented what happened.
I mean, I think that obviously, if we could expedite trial, that would obviously get a final order faster, but we have a backlog in our court system. I don't know if we could, depending on how fast we could get that trial heard. I think that we need to make sure that a judge takes into consideration factors on when he or she issues orders. And there doesn't need to be we don't need to shift the burden on an individual to have to prove why the other person is not fit. It should be more having to prove that you are fit. I think that we shift burden there and it's not good. There's a lot of other things that we could do, but expediting the trial and not forcing equal custody in the pendant light process would be the most important thing.
But if that is not, the bill that you have, any of those three things, are they covered in your bill? Expediting trial, the judge issuing order, not shifting the burden of proof? Because I didn't.
Well, we don't shift the burden in our bill. The other bill would shift the burden and match more the way, my understanding. I don't practice in Madison County. I've never had a case in Madison County. I've never been in the Madison County courtroom. So I don't know exactly how Madison County does it, but I have an understanding from what I've been told. And so that's my understanding.
And let me tell you why I'm raising these questions, because I am looking, because of my conversation with the family member, in terms of what could be done, what are the possibilities? Should we have a bill? And if it is, what should that include? So that's basically why I'm having this conversation with you.
I mean, I think that when I say expedite the trial, it's hard to do. It's hard to expedite trial because if let's say, for instance, I have equal time and I've never been in the child's life or I've not been involved, I, of course, would never want to get to trial. So what I would do is I would file motion after motion after motion just to delay, to prevent the actual trial. And you can always say, well, I'm moving towards trial, judge. Don't punish me. I'm still trying to have an expedited trial, but I think we need to do an inventory of this or that, or we need to do, you could just continuously bombard the court with motions. But I think it's just incumbent upon the court, when you have the pendant light order concerning custody, that takes into account certain factors, and the judge issues an order that he or she thinks is in the best interest of the child immediately, and not be tied to having to give a certain amount of time to one parent or the other. So during that first phase, a judge should have the discretion to decide what's in the best interest of the child. And to me, that is the best way to solve that. But sadly, a judge will never know the heart of an individual. If they appear fine and normal and they've been involved, you still might not be able to prevent such a terrible tragedy.
And I agree with that. But I'm saying if there's evidence, I seriously am looking for how we could begin to address that situation or a situation similar to that, and hopefully that another family in Alabama would not have to endure such tragedy.
I know. And I mean, like Representative Hassel said, and you have the flip side too. Well, like he mentioned, he wasn't able to see, he didn't see his child. I mean, there's flip sides to all of this. And that's the Madison County case incident. That's the worst as it could possibly be.
Exactly. So,
And we really don't want that to ever happen to any child, any parent, any grandparent. And that's, at the end of the day, what we want to do is
I
protect
agree.
children.
Well, thank you. I was looking for an answer, but
I hope I gave you one.
when you say expedite trial, we know that was part of the problem. So
But what was part of the problem is during the pendant light process, he had time with the child, which maybe he shouldn't have had.
and yeah, so I think we'll have some other conversations relative to how to
Yeah.
address this. Thank you.
All right, you're welcome.
And the chair thanks the lady. Chair recognizes the gentleman from Clark County, Representative Jackson.
Thank you, Mr. Speaker, for the recognition. I want to add a couple more comments as it relates to this bill. As I represented earlier, increased the adoption fees from $1,000 to $2,000, simply because not enough homes that are receiving our children who need parenting. The cases that you mentioned from Huntsville, and I heard my colleague Hassel talk about the flip side of that, and I understand that because some mothers use the child as a weapon against the father, and vice versa. Now, you can't legislate that. Two parents, whether they have to accept that we're not going to live together as husband and wife, and we have to agree what is best for the child. And most of the time, they don't even think about the child. They are so selfish at going at each other until the child just get lost in the process. And there are some issues that I have discovered even in rural Alabama, Southwest, where a child and mother and father would separate, and the child would be at the grandparents. One of the custody will go to the mother, but she's not able to support the child. Then you got a problem there all over again. Then he uses the child he's going to get back at the mother, so he go kill the kid and kill himself. So this is a spiritual disconnect, Representative Schaefer. You can't legislate what is spiritually broken with a physical solution. And I know you're trying to do the best you can for recover the losses that's been made, and that is the child. And I agree with you 100% there. But we also have to realize that the parents should have a dual role in that, in raising their children. And in this bill, if both parents submit the same parenting plan, the presumption is that the parents will have the opportunity to have a dual interest in raising their child if they both submit a plan. But if one of those parents submit a plan, then the judge is probably going to rule with the one that submitted the plan, and the one that didn't have a plan would not get the opportunity to have dual visitations. And also, I want to add that in your legislation, in your bill, it adds a new section to the code for action for the court that can, when parents refuse to adhere to the time sharing schedule. So what does the judge does when the parents can't get along to set a time sharing schedule? What does the judge do in that case?
Well, if the parents cannot agree to a time sharing schedule or a parenting plan, the judge will then enter the parenting plan. He will make the parties. He will say, he will take into consider, he or she will hear why they didn't enter a parenting plan and see if, mom just refused to work with dad or help him out. The judge will listen to all that and then say, well, y'all couldn't agree, so I'm just going to tell you what the parenting plan is going to be. And because you didn't work with us, that's going to affect your ability to see the child.
And that brings on a lot more animosity, doesn't it?
I mean,
with the parent. See, then when that child does see that parent that has the less visitation time, then they use that time to get back after the other parent. And this has been, this was hurting. This is what really, how can we do something about that? This bill is supposed to help that, but you got that parent that I'm not gonna let him come back. I'm gonna keep him. I may go cross the state line with my baby because I don't want him to go back to his daddy, vice versa.
Well, you won't be allowed to do that. You won't be allowed to keep the child away. And if you do, that affects your ability to see the child later. And there's a punitive aspect to this bill that if you were to say, I'm going to keep the child away, you can't do that.
All right.
You would be depriving the other parent of their right to see their child. If a judge enters an order that you have to see the child, you have to be allowed to see the child. And in fact, because of the amendment we added in Judy, that would be considered parent alienation, which Representative Pascal talked so much about, parent alienation.
All right, I just want to bring that out. This is a process.
Yeah, there would be parent alienation, and that would be a factor that then could be considered to deprive you of time with your child because you had acted wrong.
That means you will see the child even less. Thank you so much, Mr. Speaker. I appreciate you. Thank you.
No, thank you.
Chair thanks the gentleman. And the chair recognizes the gentleman from Shelby County, Representative Pascal.
Mr. Speaker, thank you for the recognition. Out of respect for the family, North Alabama, we've discussing, out of the respect for that family, there's work to be done. But it was not the 2020 standard visitation policy that Madison and 7 judges put in place. But we failed. When I say we as a state failed that family. A mercy order should not take 30 days. When a lawyer petitions the court, it should not be 30 days. So we failed that family. But to allude it to this and try to get this bill passed, I have a major problem with that. I have a major problem. I spoke to the family member. They called me. When people is getting shot, killed, they called me. But out of respect for that family, we needed it. I think we should include language in this bill. When there's a mercy order, it's already in place, but we need to put some teeth in it where the courts will follow that. But also the state of Kentucky, when I spoke to their AOC, after they implemented their law, the court dockets went down. But still, we have a problem when mother or father, anyone petition that a child life is in danger, and then we have a system that set a court date 30 days later. We need to fix that. So I think it's appropriate we carry this bill over and let's fix that. Let's insert it in the bill. I think that's appropriate. And Mr. Speaker, if we carry this bill over, is there any way we can try to find language for this bill and we bring it back up this afternoon?
Well,
I request that the bill not be carried over, and I, as a sponsor, would have the right to say whether a bill would be carried. It's my response. No, okay.
okay, yeah. I mean, you can make a motion to have this bill carried over, and then we can take a vote on it.
Okay. Well, I'm going to humbly and ask this body. We're moving in the right direction. We still have work to be done. So I'm going to humbly ask this body, I'm going to motion to carry this bill over to the call of the chair. So I think we need to insert language to address this issue.
I would.
No, Mr. Speaker. I motion we carry the bill over.
I humbly disagree, because the point that you were making concerning the dates, that's the rule, Alabama Rules of Civil Procedure. That's the attorneys abide by the rules of procedure. That's not legislative code. So they're still bound by a different set of rules of civil procedure. So even if we did that, and really the reason I touched on that earlier was because that it was dealing with pendant light situation. So even if we said, all right, for this, let's move this aside and let's fix this date. So instead of a 30-day, we can rush it to have 2 weeks, 1 day. That's still 1 day, 2 days, 3 days that we would be putting into place that equal custody that we talked about. And what I was trying to say is that by affording parent that doesn't normally have custody the right to have the custody before the trial, we have dangerous situations. Whether that's 1 day, 2 hours, it's a problem. I don't think that we need to muddy the waters of this bill with that.
All right,
I humbly disagree.
Yeah, keep in mind, members, that we got a motion on the floor, and we're going to take a recorded vote on this.
Okay, thank you.
I feel like with the votes that we're getting, we need to do a recorded vote on this motion. The motion on the floor is to have this bill carried over.
Okay.
And if you are in favor of that motion, your vote will be aye. And if you are opposed to carrying the bill over and keep moving forward with what we're working on right now, then the bill will stay on the floor. Okay, everybody understand the motion? All right? Because normally we would do like a voice vote on this, but we're going to take a recorded vote on this one. That's a call of the chair. All right?
Speaker, can I make a motion to?
Not till we get this motion off the floor.
Okay.
All right. Now, let's go ahead and if you are in favor of Representative Pascal's motion to carry the bill over, take the bill off the calendar and carry it over, then your vote will be aye. If you are opposed to that, your vote is no.
I ask that everyone vote no on his motion to carry it over.
His motion is just to carry the bill, take it off the calendar.
This bill has been worked on for 12 years. I
He
don't
wants
see
to
how
go
2
back and
hours
work on the
makes a
bill later
difference.
at a later date. It's not a temporary carryover. No, it will not come back up today. Not today.
This would be killing the bill, and a bill that's been worked on for 12 years. I don't see how 2 hours or an hour makes a difference.
Don't know. We just have to see. It goes back into the process. They'll go back, according to the motion, and correct me if I'm wrong, Representative Pascal, you wanted to take the bill off of the calendar, go back and do more work on this bill, and then see if you can fix it. That's
correct.
his intention. But there's no guarantee it'll come back. No, it's not, because we're running out of time. So that's, it may not come back up till next year. I don't know, but there's no guarantee that the bill will be back. Okay? It's just a simple motion to take the bill off the floor today and go work on it further.
And if Representative Pascal has an issue, he could work on an amendment and bring a floor amendment. We don't need to carry this thing over. Let's just vote.
All right, let's go. All right. The vote is yes on the motion or no to continue the debate on the bill on the floor right now. All right, everybody understand? No confusion. All right, clerk will unlock the machine. The members will vote. All the members voted. All the members voted. Representative Pascal, you gonna vote?
Yes. Green.
All right. Clerk will lock the machine. Record the vote. There are 11 yeas, 58 nays, 25 abstentions, and the motion does not prevail. We are back on the bill now.
Okay. Thank you, Mr. Speaker.
Yes, sir. Yes, sir. Thank the gentleman for his motion.
Okay.
All right, and Representative Roberts, we're back on the bill.
With that, I move for final passage.
Well, no, I
Well, hold on.
I got 3 minutes left.
Yeah.
Okay.
No. Once we take the vote, your
Yeah.
time's over. Now go back and turn your light back on. We'll recognize you again.
Okay.
You will be able to come back. And we've got other lights. Out of respect, we want to recognize them too. Okay. All right. The chair recognizes the lady from Calhoun, Dr. Boyd.
Thank you, Mr. Speaker, for the recognition. Do you yield?
I do, Dr. Boyd.
You know, I hesitated. I'm not in charge, but may I have a little disrespect? I'm not used to people talking and being disrespectful because I'm a teacher. And if you just listen to me, whether you agree with me or not, I would appreciate that much respect. Thank you so much. You are in my delegation.
Yes, I am.
You're young. And I sat here all day. If you notice, I'm not sick. I've been learning in my older age to listen more. When I was your age, I did not do that. If you offended me one time, I was sort of like, where's Representative Rogers? Don't mind me using him. Boy, I was just like a bunch of bees when one stings you. I have learned over 45 years and 6 months, I've learned in this house that you gotta give just a little bit sometimes. I didn't come down to preach to you, but I'm gonna tell you an incident about judges in my county. And I felt like, should you say it? But I'm gonna say it because I think this is a place to say it, even if I don't serve another day, because I'm up for re-election. Listen to me, there are some judges in my county who had gone through divorce. Maybe one or maybe more. They would not rule in favor of a female, a mother, regardless of what the issues were. I'm standing looking at you face to face. I want you to be successful even where I'm going because you represent part of my area. But sometimes you have to rethink. The bill has been worked on all of these times. Even he came to me and I tried it one time. A little bit of time wouldn't hurt to go back and relook at this. Now, some people hollering out, it won't come back. They don't know what it will do unless they're on rules. And even if it doesn't, you're young and you're more likely. And I stand here to say this today to help some others because this could be my last time standing here. But I haven't invested all of these years not to help and carry on, not what I think, not what I believe, but what I pray about and think is right. Thank you for listening to me, and I do appreciate it.
Thank you, Dr. Boyd, and I'm glad to be part of the Talladega County delegation with you. And I think you actually bring up a point that is important to be discussed, that sometimes judges rule certain ways, but we have answers for that. We have an appellate process, so if a judge rules against you, and it rules against the facts, rules against the law, I have the right to appeal that judge, and that judge could be overturned. So if a judge is just shooting from the hip and doing what he or she wants to, we can appeal that judge and get it overturned. And second, judges are elected positions. So if a judge is going out of his or her way just to do what they want, we could vote them out. So Calhoun County could say, Judge, A, you've been making so many rulings wrong, you've been costing us so much money with all these appeals, we're voting you out. And they could do that. So I think that we have a response already, which I think you have a very valid point, but I think we already have a response to your valid point now. We just have to exercise it.
Thank you so much.
Oh, thank you, Dr. Boyd. I'm probably not as young as you think I am, but
Not as
I'm
much.
probably not as young as you think I am, but
All right, members, I believe the question before us now is going to be on final passage of House Bill, and the chair recognizes the gentleman from Tuscaloosa, Representative Oliver. We're on final passage. I almost missed you there.
Mr. Speaker, on behalf of my colleague, I'd like to offer another amendment.
Okay, all right, clerk, receive the amendment.
Amendment to House Bill number 314 by Representative Oliver.
And go ahead and explain your amendment.
Once again, it asks, it readdresses the rebuttable position.
I'm sorry, would you explain that again? I didn't hear it.
The ability to rebut if you're a parent.
Yeah, read the amendment. Or either the
Amendment to House Bill 314. On page 2, line 25, after definitions, insert the following: to provide for a rebuttal presumption pertaining to joint custody. On page 6, delete lines 22 through 24 in their entirety and insert thereof the following: there shall be a rebuttal presumption that joint custody is in the best interest of the child. This rebuttal presumption may be overcome by a preponderance of the evidence set forth in written findings of fact that joint custody is not in the best interest of the child in determining.
Okay. All right, members, you've heard explanation of the amendment. Thank you. You've heard explanation of the amendment. The sponsor want to respond?
I want to move to table this amendment. I
Okay.
think it
All right.
appears at the heart of the bill.
All right, the motion before us is to table the floor amendment offered by Representative Oliver. If you are in favor of the tabling motion, your vote will be aye. If you're opposed, your vote will be no. Clerk will unlock the machine and the members will vote. Voting on a table motion. All the members voted. All the members voted. And clerk will lock the machine and record the vote. There are 55 yeas, 21 nays, 20 abstentions, and the tabling motion does prevail.
Thank you, Mr. Speaker.
Yes, sir. Chair thanks the gentleman. All right. And the chair recognizes the gentleman from Madison County, Representative Reynolds.
Thank you, Representative Robinson. You know, just a while ago, I turned and looked at some of my colleagues, and I said, if I ever get in trouble, I want that man to represent me. I said, you're a young, sharp gentleman. I find myself in a very uncomfortable situation right now. And that family has been listening to your words. And that victim's mother has been texting me for the last 45 minutes. I came to you and Representative Jones this morning. I asked, could I bring an amendment related to the Madison County case? And I believe what I was told at the time, that it did not have anything to do with this bill. And then you interjected the very case that I discussed with you in this bill. Well, why? I just don't understand. I'm open. Explain it to me.
Well, I don't think that I said it had nothing to do with the case. What I said, or with the bill, I framed it in concerning that Representative Pascal has another bill. I framed it in terms of that his bill would establish a policy that would be more in line with what led to the results in Madison County. So his bill, in my estimation, would put us more in a situation across the state that was similar to what happened in Madison County. And so that was why, in comparing, because he continued to say Madison County sets the example, Madison County is what we should follow, Madison County. So I just said, in response to his argument that Madison County is basically the beaming light, well, I want the body to know that we have issues in what you consider to be the best, and here is that issue. So I in no way wanted to say that my bill was related to that. What I was trying to say is that his bill and the position that he was taking, in my mind, would put the state more in line with that policy.
Yeah, so I guess my failure was that I agreed to wait till next year and deal with the bill that did impact the 72-hour emergency hearing. And certainly, as you know, there's an attorney involved on the other side, and I've got to be very careful what I'm saying here. But there were a lot of other issues that impact this terrible situation. And I think you mentioned it earlier about the backup in the court system. Madison County court system was backed up almost 2 years, shut down for, I don't know, almost 7 or 8 months. And I've sat at my table and I've heard that mother cry and talk about everything that occurred the months before his death. And so I don't know. I guess I would just ask you as a gentleman, could we somehow, and Mr. Speaker, I may need some help here on the protocol, could we at least stall this for just a little bit? I now, the mother has texted me back. She wants me to use her 10-year-old son's name on the amendment. But I'm a little torn because I'm told by Chairman Jones that amendment doesn't belong in this bill.
I mean, I don't believe it necessarily. I mean, you asked me a question. Let me think about the correct response. I haven't seen your amendment. I don't know necessarily what your amendment's about. So therefore, I cannot say whether it belongs or does not belong because I don't know the language of your amendment. So I can't really answer your question of whether it belongs or not. I think that is a tragedy. And it's a tragedy that we don't want to repeat. And so I just think that we need to make sure that what we do is always in the best interest of the child. And I think that this bill, 314, drives home at what's the best interest of the child. If you have an amendment, I would be more than happy to entertain it and listen to it. So I guess you asked me as a gentleman, I will entertain any motion or any amendment that you have. And if it fits, it fits. And if it improves the bill, it improves the bill. So I would definitely be interested in hearing it. But if, that's what I can promise you. I mean.
Yeah, I think, again, I came there this morning in good faith and direction and felt like that I should bring an amendment, based on that 72-hour. And even though I have to be honest, even in the current state of our court system at the time that was submitted, the 72-hour may not have applied in this case unless we put some teeth in it. I think that was mentioned earlier. And I'm certainly not an attorney. I'd like to just, if we had a little time. And again, I'm going to jump the fence here. I'm torn on that decision because I believed what I heard this morning to say, and I spoke with you as well, and I agreed, and I walked up to you here and said, hey, I'm not going to amend your bill today. I'm going to stand silent. But then when the case was brought, the very case we discussed was brought into the conversation today, I feel like I need to do something. So if there's a way, Mr. Speaker, that we could pause this bill.
Right. Well,
it sounds like we're going to be here for a while today.
when we talked this morning, I don't think I told you not to bring it. I don't know, maybe someone else told not to bring it, but then you did tell me you weren't going to bring it, and I said good, because I wanted to try to get it passed out and less debate, so I just thought that would make it easier to pass. So I don't think I ever told you not to
And you
bring.
did not. You did not. I think that's what I said. That's my failure to agreeing to wait and give this thing time and work on it together for next year. So.
Okay, and I'm sorry if I implied in any way not to.
You didn't.
I didn't want to come across that I.
That's why I had to leave that meeting and approach you to say I'm not going to amend your bill.
All right.
Okay.
Let me just address your question, Representative Reynolds. There's some other lights on, which is going to take some more time as we debate this bill. Let's see how that goes with the time, because you could have some time here left to do what you need to do. Then let's see how we progress. We're having this has been a very good debate on a very serious issue, and we're doing our job here. So let's not get frustrated in where we are. Let's keep moving forward with the process. So what we'll do is let's move in that direction. And I think there's going to be some discussion that's going to come to the floor, which may help, and then give you a little time as well. Then you can come back.
Yes, sir. I appreciate that, and I thank the gentleman's time, and I think the conversation's already beginning. So, yes, sir.
All right, good. Sounds good. Okay, thank you. All right. The chair recognizes a gentleman from Covington, and Chairman Jones, I think it might be appropriate time for you to speak now.
Thank you, Mr. Speaker. One of the things I wanted to address to try to give, and as my colleague used to say on the floor, some clarity to this situation, is this is dealing with the custody law of state of Alabama, and it's once again it's a complete update of what's been in the law for decades. There are other code sections that deal with other parts of domestic cases. There's also rules of civil procedure that give guidance to judges on how much time they have to rule on certain cases. And I'm not as personally aware of the case. It's been discussed at the well. I'm generally aware of it as of this morning, but that's it. And frankly, I try not to ever discuss specific cases like that because it tends to create problems. Yeah. So. And obviously it's emotional for people when they hear something like that discussed in a public context. But in this situation, what's being discussed as an amendment, though, would apply. I think the hearing that was at issue or the event was an emergency hearing. And when an emergency petition is filed and there's an emergency hearing, there's a very expedited timeline that goes with that type of request. There's a difference between an emergency hearing and a motion for a temporary agreement or a temporary order. If it's just a motion for a temporary order or a pending lite order, as was referenced earlier, you don't have the time crunch. You don't have the expedited time needs because it's not an emergency. We need to get to it. We need to have a temporary order in place, but it doesn't require an expedited time. If it's an emergency, and I'll give you examples that I've seen in my career of emergencies. Emergencies could include that the parents are cooking meth and the children are exposed to it on a daily basis. It could include that the one parent has literally no food in the house and is not caring for the child, and or a parent that is so intoxicated they cannot care for a child and it's a baby. Those are emergency situations that the safety of a child is immediate threat of harm or neglect. And in that situation, there are different rules and code sections that deal with that. And so if there is a reason to deal with those issues, by all means, I think that's something we take up. But this bill is not the place for that. That is not what this bill is about. This bill is more about the general law of custody dealing with domestic cases. And so I'm not trying to by any means downplay a specific case or fact situation. I'm just saying that we're talking about basically apples and oranges. It's not the same place to address. And that's the reason why I suggested to Representative Reynolds at some point when he approached me. It's not that I didn't think the issue needed to be addressed potentially. It's just that this was not the bill for that particular issue. And I'll remind the members, even a few years ago, we actually did a comprehensive review of domestic violence. And when we did that review, it was quite lengthy, and it was a lot of work. And we touched criminal law, we touched domestic law, we touched areas of all over the code, including things to help law enforcement. And during that area of law, we also dealt with some of the emergencies that take place in dealing with domestic violence cases. And so all of that is sort of somewhat connected to as well. I say that to say, if this were the place to touch that issue, by all means, we should do it. I don't see that this particular bill deals with those issues. However, there are other locations in the code that would deal with those issues that if we need to address, then I'll be glad to help. This is an area that I've dealt with my entire career, so and I've told that to Representative Reynolds. If this is something we need to address, I'd be glad to assist with that.
All right, Chair thanks the gentleman. Some more explanation. The chair recognizes the lady from Madison, Representative Hall. Is she in the chamber? Representative Hall? You're out there working, aren't you?
I'm trying to figure out where we are, Mr. Speaker. There's a word on the street that we're not going home tonight.
Well, I don't know. Oh, I'm sure we'll go home tonight. Yeah. Come midnight.
But not anytime soon.
I'm just trying to help House members here. That's what this calendar is all about.
All right, so
because this is crunch time on House bills.
I got you, but I mean, it sure would have been nice if I had known this. But okay,
Yeah.
But all right. Where are we, Representative Robbins? Where are we on this?
Well, we're on final passage.
So that means the amendment that's being proposed or considered, you're not looking at that?
Well, it hasn't been introduced, so procedurally, right, Speaker, we're on final passage.
But I was thinking that we were at this pause, really, and that's why I'm here, is to see what is the status or what are the possibilities of that amendment, and what do you envision that's going to look like?
I mean, I hate to speculate and envision, so I'd hate to say something and then it not be there or be totally opposite. So I think my answer to that will be whatever it is, Representative Reynolds will bring a very well thought out and written amendment that we'll review and debate as a body.
Yeah, the brightest heads in the body seem to be over there convening, so I was trying to find out that what we were doing. But I do think that if there is an opportunity to address the concerns and some answers to the questions that I raised, and that can be done in this bill, I certainly would appreciate that, given that consideration. Now, I don't know that that's going to be the case. I don't know. It seemed like you might have been open for that possibility.
I am, as long as it fits within there. And like I told Representative Reynolds, I'm open to anything. I mean, that's the whole point of the body. I'm open to any motion, any amendment. It doesn't matter. I'm willing to listen to it and read it over and debate it. I'm not going to shut someone out just because I just don't want to hear it. That's the whole point of us here in a chamber, is to be deliberative. And that's why I like you so much, Representative Hall, because you are deliberative. And I think you do your job and you come down to the floor and you ask questions and say, did you think about this or what about this? Because truthfully, that's what we all need to be doing. So I appreciate the work that you do.
Well, I appreciate that, but I'm just nosy like that. You read something and you're not sure on it, then you ask questions, and I always do that. But I do want to, if you were talking about the gist of the bill and based on what we've talked about possibly adding, how would that impact your bill in any way? And without having the language present, I know.
To be honest, I'm not going to be able to answer your question just because I don't know what the amendment is, and without knowing what the language is, I have no idea how it would play with it. So I can't answer because I'm afraid.
Okay, so let me just give you a gist of what I think I would envision a language. And you remember now, I'm not the attorney.
Right. Well, I'm an attorney, so I'm not going to give you an answer here.
You're not. You're an attorney, so
right. So I'm not going to give you an answer. I'm going to have to say I've got to read it. I've got to see it. Whatever.
That's smart.
Whatever you say you envision, I'm going to turn around and say I'm sorry, but I might not envision it that way. Or I've got to read it.
And that's fair. That's fair enough if you don't envision it in some way. But in light of the fact that we've mentioned Madison County, and we mentioned the case, and you mentioned that it could be a choice, or someone mentioned to me that there were two different situations that order could have been under: emergency Order.
Well, they were. My understanding is, and I don't really know all the facts of I don't know the exact facts of the whole case. I wasn't involved with it. I just like with everything, I only know from. I will admit, I didn't know anything about it until Representative Reynolds told me about it, and it just kind of. I Googled it while we were up here because it triggered in my mind when he was talking about Madison County, and I took the news story while I was sitting here. You know how you think of things that are you things bounce around and you remember them and say, oh, you're talking about this, let me review this, and it came to me from the news. So just like with the news, you never know exactly what it means, and you don't know all the facts. So I won't even make a statement on all the facts because I haven't read the whole the entire I haven't read the whole docket. I haven't read the whole pleading, all the pleadings and the evidence and everything. But my understanding is that they were waiting an emergency order.
Okay, so my reason for coming to the mic, if you recall, prior to your mentioning of Madison County, it was in reference to a discussion that you were having. That's how I ended up at the mic trying to see and ask the questions in terms of what would you do or how we could address the issue that had happened in Madison County within the bill. And it didn't seem to be it did not seem that there was an opportunity for that from your response.
Right. I would say I wasn't sure that there would be an exact fit within there, but like I said, I'm willing to hear and entertain anything that someone might bring.
I didn't get that part to my response, but it's okay.
Okay, well, I'm sorry. I mean,
listen, hold up, just a minute. That is not necessary for me. Because if I had an amendment and wanted to bring it, I would have brought it if
That's true, you would have.
Yeah, even if I thought it was going to be voted down. So that's not necessary for me. But I felt like in light of the fact that I didn't have all of the information and did not have a clear, thought out understanding, it would be presumptuous of me to try to put something together when I was not sure the real impact that it would have and the likelihood that particular amendment might have been rejected. So as we move forward on this, I hope that those people are giving you good information in terms of how we should respond. I think that the dialogue that you've heard from the gentleman that talked about the experience he had with his son and not being able to visit with him, to individuals who've had different experiences, that we make sure that every child, and I think that's been the goal and the objective of your bill, it appears to be that the focus is on the child and in the child's best interest.
Right.
And when we take the child's best interest, even from the individual that has been in opposition to some of the things that you've done in this bill, what I have heard, even if the child's best interest, that the bottom line is that if we all take the child's best interest, we're going to have a much more productive citizen, one that feels that he or she is loved, and the opportunity for them to have a productive life is very likely the possibility as opposed to that. So thank you, and we'll see. Oh, they're not there.
I think
they're back there.
I think they've mingled around and moved around.
Right. Okay. Well, I thank you for listening. Thank you.
Thank you.
And the chair thanks the lady. The chair recognizes the gentleman from Baldwin County, Representative Simpson. You are recognized.
Thank you for the recognition, Mr. Speaker. This has been a very difficult issue, and many people are correct in what we've said here. This will be one of the bills that touches lives the most. A lot of the bills that we pass, not everybody will have to deal with, not everybody will have to see, but there's a lot of people, divorce rate is incredibly high and the children will have to suffer through this. I think there's a lot of work to be done. I want to commend Representative Pascal. I want to commend yourself, Representative Robbins. You guys have immersed yourself in learning this detail. You know, you get a bill and normally you just kind of think, hey, I'm going to go with what they assign, especially coming from ALI. But I think a lot of the concerns that have been addressed today, and I've been with you. I've been with you every step of the way. But a lot of the concerns that have been addressed today have really turned a light on as far as maybe this bill isn't ready until we can fully go forward and say we know exactly what we're talking about and what we're going through here. When we have the Madison County delegation and everything that occurred with that poor family, with that incredibly sad situation that occurred that can cloud the judgment of what's going on here. Representative Robbins, you know I'm a big fan of yours. I consider you a friend, and I think you are absolutely a brilliant legal mind. But we're 5 days left in the legislative session. We're 4 days left in the legislative session after this day. We do not know what's going to happen in the Senate as far as, do we have a Senate sponsored? What are they going to do? What are they going to change? What do we have here? So we're sitting down now with a lot of bills that are left on the calendar today that we're spinning our wheels, and we can stay here till midnight and we can have this discussion and go till midnight, but we're drafting amendments. We're drafting what we're talking about here. What I would ask is that we simply temporarily carry this over to the call of the chair to address these amendments, to address these concerns, to address what we're talking about, because we only get one shot, one bite at the apple. We don't want to pass a bad bill that has an error or has a problem with it just because we didn't have this discussion. I appreciate the people at ALI. I support the people at ALI. They know this issue in and out better than I do, but you clearly see the concerns that people have with their districts, and they've got to go back to this, and this is what's going to have to go back, and this is one of those single issues that we've hit where you have single issue voters that this is what they care about, and we need to know exactly what we're talking about. We need to not just, hey, it was 5 o'clock on Thursday on the last day of session and we're trying to get stuff through and we passed it. Let's take some time to make sure we get the thing right. And with that, Mr. Chairman, I would move to temporarily carry it over at the call of the chair.
I understand what you're saying, Representative Simpson, but have you ever heard the phrase, when you're going through hell, just keep going? We've already committed hours to this. Let's just go ahead and wrap it up.
That's not fair to the people we represent to say we went through hell, so we kept going. That's not fair to just say we went through this.
No, I think it's not fair to the members.
All right, hold on. Listen, hold on. We've had a good debate. Let's not get all upset here, lose our perspective on where we are. This is, number one, this is not a debatable motion. And keep in mind that if we move this, if this motion was accepted at the call of the chair, the bill would have to come back up on this calendar today. So whatever work would have to be done, we would have to do it, and then the chair can call the bill back up on the calendar. Keep that in mind. So it's not like the other motion we had where we were just going to put the bill back out to pasture, if you will, excuse the term. So if we carried over temporarily at the motion, and we're going to take a recorded vote on this, if we carried it over, and it's not a debatable motion, so we're going to the motion is to temporarily carry the bill over at the call of the chair. And then the chair would call the bill back up at another time today as we move forward.
That's
okay.
correct, Mr. Speaker.
All right, members, that's the motion on the floor. It's not debatable. Let's get ready to vote on it. And the motion on the floor now is to carry the bill over temporarily at the call of the chair. And that answers your question a while ago. That would come back up today. All right? If you are in favor of that motion, listen up, members. Let's make sure we know what we're doing here. If you are in favor of this motion, your vote will be aye. And if you're opposed, your vote is no. Clerk will unlock the machine and the members will vote. All the members voting. All the members voted. Clerk will lock the machine, record the vote. There are 68 yeas, 16 nays, 9 abstentions, and the motion does prevail, and the bill will be carried over temporarily at the call of the chair. Okay. And I would hope, Representative Robbins, we've come a long way today. Let's keep working, please. Let's get with the interested parties and let's keep working on this bill because we have spent a lot of time and this is an important piece of legislation.